Judges are here.
Yeah.
Okay.
All right.
Yes, Mr. Brennan.
Thank you. We've just looked at the schematic overview, which is page 7. I can move on. Page 8 is a rather uninteresting diagram of the reinforcement of the headrails after the collapse. So shotcrete. This is stuff, concrete, which is sprayed onto the surface.
Right.
I don't think we need to pause on it for the moment.
Yeah.
9 is a picture of the trench for that great big constructed on-site aqueduct. 10.
Well, which of the conduits is that? There were 4 conduits, of which 3 are now under appeal. So
That is the cut and cover tunnel built on site.
This is tab 9, is it?
No, tab 8.
Oh, it's tab.
Yeah, the tabs and the pages
Are different.
in my bundle seem to be different.
They are different, yes.
So this
Because,
Sorry about that.
so it's page 9, tab 8, is it?
Right, so you dig this tunnel, which we can
You dig this trench,
and
and install in it the framework, which we've seen in an earlier picture, reinforced steel reinforcement, and then you cast onto it the using a neutral word, conduit.
so is that what we saw at tab 5?
Tab 5, page 6 is an
I see.
example of it. There's a better one coming up, I think.
Okay.
So that arch of steel is a section onto which concrete will be cast.
From the inside or from the outside?
I'm not sure. I think it's.
Well, what does it look like in the end?
You'll see that in a moment.
Oh, okay. Right. Oh, I see.
I think it's cast with shuttering, so there's probably shuttering on the inside and poured. So at page 11, probably behind tab 10 unhelpfully, that's what it looks like when it's cast. So you've just looked at the steel
So
reinforcement.
it's like a roof over the top half is a roof above ground.
Yes,
made out
although
of
I think it
concrete.
almost certainly has a concrete floor as well, a flat concrete floor. Otherwise, you lose water by leakage into the surrounding soil.
Yeah, and then water goes through the whole thing,
Yes,
the whole diameter of the.
yes.
Mhm.
There's another picture on the next page, a little bit clearer. So it's, including the floor, hexagonal in cross section of a regular hexagon.
Right, and just remind me what was decided about this. So the FTT said
Said it was an aqueduct.
they said it was an aqueduct.
And was therefore disqualified, but that List C item 22 operated so as to preserve the expenditure on only installing it. So all of the cutting, the digging and refilling expenditure qualified via item 22.
Right, so what wouldn't be covered? What wouldn't be covered by?
All the concrete, all the steel reinforcement. And of course, either way, we are talking about millions of pounds here.
So installing it, so digging the trench and then casting the lid,
Yes.
roof, whatever.
My lady, if it helps, in a few moments when we finish these pictures, I'm going to look at the assets separately by reference to my skeleton, which
yes, no, it's helpful for me just to
Of course.
think about it, looking at it.
Yes.
Right. But the cost of the concrete not.
According to the FTT, yes. And the Upper Tribunal said it wasn't an aqueduct and therefore wasn't disqualified. Didn't look enough like a bridge.
Because you don't go on to 22B, 22(1)B if it's...
Momentarily forgotten how they dealt with the installation expenditure. It wasn't disqualified, so the whole of the expenditure was on the provision of the asset. Nathan will correct me if I'm wrong, but I think I'm right. But it may have either way. It may have qualified under item 22 of list C.
All right.
But they certainly allowed the whole of the expenditure on that item. Page 13 is not in dispute. It's included, but it gives you some context. This was found to be a pipeline. In fact, a double corrugated plastic pipe, clearly of enormous size. And so it survived because of item 25.
Yes.
Don't read page 14, I don't think. Page 15, again, this is really contextual. This is one of several photographs of the intakes, which go into what we say are aqueducts and the taxpayers dispute, and you can see how each of these is labelled.
So is this upstream of the reservoirs?
Oh, yeah, it's upstream of everything. This is, it's not immediately obvious what you're looking at, I have to say. What you are looking at is a pool, quite a small pool. There is an item that looks like a tin can behind the blue pipe. That's a siphon. So when the water reaches the level of the bottom of the siphon, it is siphoned out and goes into aqueduct 4, for which it is intake number 8. And the wheel on the blue pipe will operate a sluice, I think, in case of overflow or maintenance. That particular item not in dispute because we lost on that.
I think your junior has something she'd like to pass to.
Ms. Northam refers me to the Upper Tribunal's decision at paragraph 151.
This is going back to the cut and cover.
The cut and cover, yes, and particularly 153.
So this is page 12.
The Upper Tribunal at 153.
Well, I can check that, don't worry.
Yeah, that's the reference. It's 151 to 154 and 153. The 16, we don't need to pause on. It's another bit of intake. 17, ditto, pass on. And that's all of the illustrations that I wanted to.
Can I just confirm one thing? At tab 5, page 6, this particular thing, I forget what this is, but this doesn't relate to, for example, what we saw just now on page 12 of tab 11, does it?
Indeed it does.
It does it?
Yes, it's the same thing, at a different stage of construction.
I see.
Same day.
Well, that's what I found. You're quite right to say it's the same day, so it must have been further down somewhere. Or...
My lord, it's not actually the same day, it's a month later, but...
Oh, is it? Oh, it is a month later, you're quite right. Anyway, it's the same thing, you're both agreed on.
Yes.
Yes, fine, thank
Yes.
you very much. Okay.
So the cylinder is made is half below ground, say, in which it's dug out, and then it's half above ground, the above ground cover being made by that steel frame with concrete cast over the top of it.
No, not in the course of construction. What your ladyship says is right.
Yeah.
But in due course, the whole thing will have been covered over, and all you will see is heather.
Oh, I see. So page
This
12 isn't the finished item then?
no, it's going to be covered in. There were all sorts of restrictions because this is deer stalking country,
Right.
and so you wouldn't know that these assets were there unless you were, except for the intakes. You do see the intakes
Yes.
and the reservoir and so on.
Okay. Well, thank you for that.
We went there twice and were told on each occasion we might see golden eagles, but didn't
Oh, well.
either.
Oh, shame.
Those are the illustrative documents. I now want simply to, without reading them out, point to the relevant paragraphs of my skeleton and deal with those assets
Yes.
specifically. I've tried to set it out with some care as to what we say about each of them and by reference to what the two tribunals held. So my skeleton, which you will find at here, core page 29, this is the blasted underground conduit, so that's the 6-point-something kilometre one, which appears on that plan we've just looked at as the aqueduct tunnel. And you see from para 61 what I say about it and how I criticise the findings of the two tribunals below. Then moving on, unless the court has questions, the conduit, that hexagonal conduit we were just looking at, is dealt with from paragraph 68 of my skeleton. We just looked at the photographs of it. And I say it's an aqueduct and also stems from alteration of land.
And why is it you say that it results from works involving the alteration of land? Is that the initial digging of the trench, or is that the covering it all over with soil at the end?
I put it on the basis it's everything. It's digging in the trench, it's constructing inside the trench with steel reinforcement and concrete and covering it over. So that if it isn't an aqueduct, my primary case is this is an aqueduct, which is what the FTT held it to be, finding of fact. That survives if, but only if, an aqueduct in this context does not have to look like a bridge. If it does survive, then I submit I succeed on aqueduct. I also
Right,
submit
but if you have to apply 22(1)(b to it, what is? I don't really understand how you apply that. I mean, you've got. We saw you have to buy and construct that steel mesh, and then you have to cast all the concrete, and then you have to put all the soil on top of it. So what of all those costs is works involving the alteration of land?
Well, all of the digging, the casting of foundations, installation of steel, casting of conduit and covering over. Now, I do
What
recognise...
about buying the concrete?
Oh, yes, that's all part of the... That's all of a piece. Buying the raw materials is all of a piece with the construction.
When I pressed you on what was meant by involving, your answer was that involving alteration of land was aimed at where land was being altered so as to function as plant. So do you say that this is an example of alteration of the land so that the land can function as plant?
Yes, but let me be realistic about it. I recognise that my argument is more vulnerable on that than it is for something like the head race, which is essentially the drilling of a hole to function as plant. Because there is that significant element of construction. Provision includes in construction. But I do recognise that I'm trying to ride two horses slightly on 22(1)(b) in relation to this asset.
Thank you.
But you say that there's nothing that's no expenditure incurred in creating that thing that we saw, which is outside the scope of works involving the alteration of land, and none of it is incurred in installing that thing.
Yes. The reliance by the tribunal, the first-tier tribunal, on item 22 is, I submit, completely misplaced. You're not installing something when you're actually constructing that very item on site. It's different if you bring it to the site and put it in the hole. Then you could be said to be installing it, but not making it.
But then making it is all work involving the alteration of land.
So I submit, subject to the qualification which I just shared with Lord Justice Popplewell.
But just one last question. You don't have a difficulty if the court was with you on the installing part, but can one divide up different parts of the works like the FTT did to say, well, some of creating that thing is works involving the altering of land, but it's difficult to see how casting concrete and putting concrete over the top of the trench could be described as a work involving the alteration of land.
Yes.
Unless you say that because it involves some alteration of land, then everything is.
Yes, and I recognise the vulnerability of my argument on that aspect. But on the aqueduct, construction, if it's an aqueduct, construction, forgive me, provision of the aqueduct includes its construction. And in my submission, the provision of this item from virgin moorland to start with to the appearance of virgin moorland to end with now the aqueduct underneath it, that is all the construction of the item. And in my submission, it's all disqualified. What the FTT did was to say it's an aqueduct, so it's disqualified, but you can still have the huge cost of digging the trench and building it, digging the trench and covering it up again, not of building it in there. They disallowed that.
On the basis of item 22 in list C?
Yes.
Yes. So
They said that was only installing it.
that was just installing it.
I haven't banged that drum very hard, but item 22 is only installing.
Yeah, no, I follow. And you say they were constructing here, not installing.
And provision includes construction. We have that in section 22.
But what's
Yes,
the relevance
indeed.
of that when you're looking at 22(1)(b? Because the provision
It isn't.
point is
22(1)(b) is a standalone disqualification, if I'm right. So that was, in my skeleton, paragraph 68 to 73. I don't think we've got photographs of the next item. They wouldn't be very exciting if we did. They're channels in the ground, uncovered, and are either lined with rock or with concrete. And the FTT made the same mistake as I would have it with these. They said they were aqueducts, but the expenditure, the whole of the expenditure here, was saved by item 22 because it's on, as they would have it, only installing, when that installation involves digging the trench in the first place. The head race, my treatment of it starts at paragraph 79. As you know, I say that it's a tunnel and or it's an aqueduct, and the FTT found in my favour that it resulted from works involving the alteration of land, clearly right, but the stinger was that the FTT held that the whole of the cost of boring the head race qualified as only installing that void through the route of item 22. And I've made my criticisms as set out in writing. I won't repeat them to you now. The tail race, skeleton in paragraphs 87 to 89. I submit that the treatment it should be the same as the head race. It's a tunnel and it's an aqueduct and it's alteration of land. It looks like the FTT nodded slightly here, didn't address the arguments about tunnel and alteration of land. But one can be confident that they wouldn't have decided it in my favour, given what they did say about the head race.
And it's not the installation of anything, so none of it is saved by item 22.
Well, they held that it was. My submission is that it plainly isn't. The head race and tail race really are almost literally of a piece. They're in a straight line, subject to that dogleg after the collapse, drilled by the same tunnel boring machine, which just ascended up the mountain. The ancillary tunnels, the drainage and dewatering tunnels, are, I think they're drilled and blasted. But the head race and the tail race are identical in character and function. As I've submitted in writing, they carry literally the same water.
Yes.
But with the engineering difference that it's under high pressure and speed in the head race, and it's not under pressure in the tail race. It simply flows out through an unpressurized tunnel.
Yeah.
Then the turbine outflow tunnel and the drainage and dewatering tunnels attract the same treatment as the tail race. They're used occasionally, if it's necessary, to dewater the head race and that sort of thing.
Yeah.
So those are my submissions on how those assets should be treated. I've said, no doubt, too much about item 22, which is raised by my learned friend's respondent's notice. He wants to get that back on its feet, having failed to persuade the Upper Tribunal of it. And also in his respondent's notice, he contends that the various things that I say are tunnels or aqueducts should be characterised as pipelines.
Right.
My submission, accepted by both tribunals below, was that pipeline in this context connotes some kind of jointed set of pipes. I speculate in writing, but I bet I'm right, that it's there the pipeline is there to preserve existing treatment for assets in the oil and gas industry.
You'd say a pipeline is a prefabricated container which is laid in the ground.
Line of pipes.
I mean, it might be, a very short one might be just one length, but the likelihood is a pipeline will actually need to be a number of lengths.
Yes, and as you've seen, you saw pictures of that great big double-barreled
Yes.
pair of pipes. So that element of the water gathering assets was held by the FTT to be a pipeline. I accept that that's an available conclusion, so I haven't appealed that.
Yes.
I submit it's simply not an available conclusion for the other assets. It's simply straining the words to fit a conclusion if one goes by that route. So that concludes my treatment of the assets under the errors of law on those assets. I have my 8th ground of appeal, the important point of practice, which is whether a respondent to an appeal to the Upper Tribunal requires permission to appeal if what he wants to do is to cross appeal. Now, we're all familiar in this court with a respondent's notice by way of cross appeal. There is no such express animal before the Upper Tribunal. So what happened, as you've already seen from the Upper Tribunal's decision, is that we flagged up in our response to Malin Friend's respondent's notice in the Upper Tribunal that he needed permission to appeal in order to get that great big cut and cover aqueduct, the reinforced concrete one.
Yeah.
His position, as we understood it before the Upper Tribunal, and I haven't seen this disputed yet, was that he was not, in fact, before the Upper Tribunal, trying to do better than he had done before the FTT. If that was the position, then obviously he didn't need permission to appeal. Appeals, obviously, lie against results, not reasons. If he wanted to alter the result of the FTT, he needed permission to appeal. That put him into time difficulties. His answer, as I understand it from his skeleton argument, is to say, well, it was only 1% of the total expenditure. Well, 1% of the total expenditure is still millions of pounds, but let's leave that for the moment. And it wasn't worth an appeal by itself. But once HMRC had appealed in the way that it did, it became worth an appeal, but by then we were out of time. I've set out in my skeleton argument the statutory route through the Tribunal Courts and Enforcement Act, the FTT rules and the Upper Tribunal rules. It is, I submit, obvious that the cross-appellant in these circumstances requires permission. If he's allowed it to go out of time because he has not, as many people do, put in a protective appeal, then he will need to go to the FTT to ask for permission. He may be able to persuade them that it's perfectly reasonable circumstance in which to give him an extension of time, because HMRC are now taking him to the Upper Tribunal anyway, and so it now becomes worthwhile to appeal something which wasn't worth the investment beforehand. He might be able to do that, but it wasn't done. And Malin Friend's skeleton says it's neither here nor there that they were put on notice about this. In one sense, I agree it's neither here nor there, but it's, I make the point that they were put fairly and squarely on notice about this, so as to head off any suggestion that some point is being sprung unfairly. It's not been sprung unfairly at all. And the way in which the Upper Tribunal dealt with it, quite wrongly in my submission, was to say, well, it's all a matter of case management. It's not a matter of case management, it's a matter of law. The tribunal could not grant itself jurisdiction to determine this point without granting permission to cross-appeal. They refer to the provision...
Could the Upper Tribunal have dealt with an application for permission even at the hearing once it came up, if there hadn't been a request for permission to the first hearing?
Well, it depends on the extent to which the dispensing power in the Upper Tribunal rules would allow them to dispense with an express provision that if you're going to ask the Upper Tribunal for permission, you must have asked the FTT first. Yes. That's expressly in the rules.
Rule 21, which is behind my tab 13.
So
I'm just trying to work out the practicalities of this. So you say, well, yes, you can see that they might not want to poke the tiger in the cage by appealing themselves. Exactly. Let's see if HMRC can live with that result, because we can if they can. So time can go past, can expire without them knowing, I think, that you've lodged an application.
It can.
So they sit tight, then they get served with what, with the application, or just with the notification that permission has been given?
I think with the notification that permission has been given, because they don't need to be told that we have applied for permission. So that the bad news, the first they hear of the bad news may be that we have been granted permission.
Right. And so what do you say they should do then?
If they now change their minds, the sensible course, if you've got a £1 million plus point that you might want to appeal in due course, is to apply for permission in order to preserve your position. If they failed to do that, then I accept they are already on the back foot. But once they decide that they want to appeal out of time, what they should do as a matter of practicality, and this long before the matter gets before the Upper Tribunal, is go to the FTT and say, now that the other side have appealed, and we're being taken there anyway, we want to cross-appeal. Please may we have permission on this point. And if the FTT will either say, no, you're out of time, or no, it doesn't merit it, or yes. If it say yes, obviously the point disappears. If they say no, then they can go to the Upper Tribunal and say, we've asked the FTT for permission and that's been denied us, so please may we have permission from the Upper Tribunal.
And will HMRC be asked for its views by the FTT as to whether permission should be given to the cross-appeal or not?
I'd be surprised if it weren't, because because we have once they're out of time, we have an accrued right, do we not, to the win, and I can't immediately bring the case to mind, but there are authorities to the effect that once time has expired on an appeal, a potential appeal, the successful litigant, who would have been the respondent to the appeal, is entitled to regard the matter as closed. So it would be inappropriate, I'd suggest, not to give us permission to appeal. Forgive me, the opportunity to
comment on the extension of time.
Comment. But there are only two comments one could make. One is to say, it's late, and that's all very sinful, which doesn't really illuminate the judicial decision very much. The other is to address prejudice. Now, if you can address prejudice, all well and good, and if you're prejudiced, that might be a reason for depriving the other side of their extension of time and consequent permission. I'm not arguing prejudice here. The Upper Tribunal was perfectly entitled to take the view that I wasn't prejudiced by this point being raised in the Upper Tribunal. But where they were wrong was to say that Mullin and Friends clients didn't need permission because they could just put in the respondent's answer. But the respondent's answer, of course, which permits a respondent to an appeal to address a point on which he was unsuccessful below, treats him in his character as a respondent. If what he wants to do is to challenge the decision below, he's an appellant, albeit by way of cross appeal. And that's something with which the Upper Tribunal never engaged. So it's quite wrong, in my submission, for the Upper Tribunal to have said this is just a matter of case management. It's not a matter of case management, it's a matter of law, and it's a matter of primary legislation. And while, even in a case like this, a floodgates argument is never very attractive, just bear in mind, I've mentioned this in my skeleton, what sort of litigation comes before the statutory tribunals under the 2007 Act. And a matter may come before the Upper Tribunal, perhaps on a narrow point appealed by the Secretary of State in whichever chamber, and be met, if the other side doesn't require permission, by a general challenge to everything that happened below, addressed as if it were a point of law, and without permission. Edwards and Bairstow challenges every other legal point on which the litigant lost. And if the court is not with me on this, that opens up that position, that anything can be brought before the Upper Tribunal so long as you're a respondent.
Well, if they're right, then they are in a much better position than a respondent under the CPR. If you're right, they're in a more awkward position than a respondent under the CPR.
Yes, and but if they had addressed the awkwardness of their position when I drew attention to it, they would have been in a position to say to the FTT, please can we have this extension of time? They're not prejudiced. We're not going to be before the Upper Tribunal for 12 months, and it's a point of law on which all the relevant facts have been found. And the FTT might well have decided as a matter of discretion to give the extension in those circumstances. But none of that was done. They could have applied in the first place as a protective appeal, but didn't. They could have applied for an extension of time when I drew attention to the point, but they didn't. They could have, if they had applied to the FTT, they could have gone to the Upper Tribunal and asked for permission, but they couldn't and therefore didn't. The Upper Tribunal didn't grant them permission, didn't have jurisdiction to do so because a valid application had not been made to it, and didn't purport to grant them permission anyway, but simply embarked on deciding a point which wasn't before it. I've referred in my skeleton, I don't think it's necessary to turn this up, to a case called Price, where Mr. Justice Newgee, it's at tab 27 in the authorities, and it's highlighted. Mr. Justice Newgee deals in detail in the context of the Upper Tribunal with the need for when you do and don't need permission to appeal. And the upshot of his decision was that if you're challenging the order below, which is what my learned friend was doing.
Well, you have to be careful because there is no order. That's part of the problem, that there isn't, as there is with this court, an order following on the judgment.
Your Ladyship's right to correct me, challenging the result below. And in that, because your Ladyship makes that point, perhaps I should look briefly at what Mr. Justice Newgee said about that.
Tab 27.
Tab 27, yes. Has its slight factual complication, but what happened was that I was in this. I was acting for HMRC, and I had lost, slightly unexpectedly, on what was described as issue 1. And my learned friend Mr. Hewitt had succeeded on what was called issue 2, and I wanted to argue that issue 1 had been wrongly decided by the tribunal, but I wasn't seeking to alter the result of the case. But Mr. Hewitt took the point that I still needed permission to appeal, so we got into to cross appeal. So we got into that line of cases from Lake and Lake, which I'm sure the court will remember, where it's a divorce case where the wife was held to have committed adultery, but it had been condoned by the husband. So she won on a defended divorce, but with the unpleasant outcome that a finding of fact of adultery was made against her. She was unable then to appeal that, because in that context, appeals lie against orders, not against reasons for orders. So I'm just looking for the, it's an authorities bundle, page 313, behind tab 27. The permission issue. What you can see from the highlighted passages is that the taxpayers were appealing decision 2, and I wanted to challenge decision 1 if they had been successful on decision 2. And at letter G on internal pagination 1984, Simon's tax case is 1984 at little g. HMRC had applied for permission to submit a response and got from the appellants a response containing extensive argument, including the point that I couldn't properly challenge decision 1 by way of respondent's notice, and that I'd need to apply to the FTT for permission to appeal and for an extension of time. And the way the decision went is that Ms. Justice Nugee decided that my clients didn't require permission to appeal, because what we were trying to do was to uphold the outcome of the decision before the FTT. So I had been right not to apply for permission to appeal, but merely to submit a respondent's notice.
Right. But here I think it said, well, these items are all interrelated in the sense that the same decision about aqueduct, tunnel, installation applies to more than one of them. And given that you HMRC have raised these issues of what is the meaning of tunnel, once this court decides what tunnel means, then that must be applied to all these assets, even if that means that actually the amounts allowable or not changes. But you say, well, even if somebody wins on something like that, if there's been no permission granted to challenge the actual allowability of an item, even though the logical consequence of our interpretation of the statute would be that it is now allowable, whereas formerly it wasn't.
Would have been if it was before the Upper Tribunal.
Right, but that's just too bad.
That's just too bad. These assets are treated separately in the decisions of both tribunals. This one, you recollect, depends on whether it's an aqueduct. And the FTT has held it was not an aqueduct. Forgive me, held it was an aqueduct, and then made the item 22 error. If the taxpayers wishes to challenge the proposition that it was an aqueduct, they needed to challenge it. But it wasn't under challenge by them at all. It was my appeal to the Upper Tribunal, which I was making my points about aqueduct and tunnel and so on. And what it needed, if the taxpayer was seeking to do better by some millions of pounds, was a permission, first an application for permission, the grant of permission, to say this hexagonal concrete monolith was not an aqueduct, and it's an error of law to say that it was an aqueduct. But they didn't do that. But my core point, if I can put it like this, is it simply wasn't before the Upper Tribunal. The Upper Tribunal wasn't entitled just to say, well, we're going to treat it as if it's here.
Yes, but I know from experience that sometimes these cases are argued between the taxpayer and the revenue on the basis of, well, these are the questions of principle that have to apply. What is the correct meaning of tunnel? What is the correct meaning of aqueduct? What does installation mean? And never mind, O Tribunal, how you apply it to the facts. You decide these issues of principle, and then we'll go away and argue amongst ourselves as to how they apply to particular items. Now, this case wasn't dealt with on that basis, and that's in a way where the problem arises.
Absolutely, absolutely. You see, and at one time, before the FTT hearing, the assets weren't split up in quite the way that my learned friend analysed them when we came to the hearing. So we were looking at questions as whether there was one system or one entity of water gathering assets and so on. And my learned friend, make absolutely no complaint about this, perfectly appropriate thing to do, split it up and said, right, well, there's this sort of asset, concrete, aqueduct type things, there's this sort, pipelines, there's this sort, siphons, intakes, and so on. And we looked at the water gathering assets by reference to particular categories. So it was not a case of litigating points in principle and then working out the figures.
So, in respect of this particular item, the decision of the first tier tribunal was to allow the taxpayer's appeal against the closure notice to the extent of X million pounds.
In relation to the excavation and refilling works. So they got...
Yes, well, that's my X million pounds.
Yes.
It didn't actually quantify them.
Oh,
I'm sure that's right.
Well,
no.
None of these figures have yet been
Not
agreed.
being quantified. I see. So in that sense, they are points of principle. I mean, they're very much grounded in the facts, as I have.
We don't anticipate that agreeing the figures once the principles are known
No.
will be difficult,
All right.
but they have not been agreed.
No, thank you.
I accept that. So there's what you might call a quantity surveying point, which is still live.
See, I'm being. I'll tell you why. I mean, I've been looking at the relevant provisions. So I've looked at the statutory provision and I've looked at the rules. And I'm just trying to fit this discussion into the words of the statute and the rules, which, after all, in the end, is what governs this question. So, I mean, just looking at the statute first of all, which is at tab 10 under one of the authorities. So it's section 11 of the 2007 Act, I think.
Yes.
That's what we're concerned. So 11.1 says that, I mean, subsection 2 says any party to a case has a right of appeal. And subsection 1 says that a reference to a right of appeal is to a right to appeal to the Upper Tribunal on any point of law arising from a decision. So you appeal, I mean, putting that the other way around, you appeal against a decision on a point of law. I think that's, which is actually how the draftsman of the rules has understood it, because at tab 13, rule 21, maybe I should look at the first tier tribunals, but the Upper Tribunal, a person may apply to the Upper Tribunal for permission to appeal to the Upper Tribunal against a decision of another tribunal. So you appeal, as you might expect, you appeal against a decision.
Yeah.
So I'm just trying to work out, well, what is the decision here we're talking about?
It's what came out from the FTT.
Yes.
This was not a...
So you would say, sorry to cut across you, but you would say the FTT decided that this was an aqueduct. And you say, well, if the taxpayer wanted to appeal against that decision, it needs permission.
Yes. And it is...
And on a point of law.
It is nothing to the point that I have an appeal myself on other points which I contend involve aqueducts as well. So I have a point, I had the point before the Upper Tribunal, that the head race is an aqueduct. I might not have had that point. In fact, I did. It doesn't tell you anything about whether my learned friend needs permission to appeal on his aqueduct point, that I've got an aqueduct point. But I've got an aqueduct point because I got my appeal in on time.
No, but the decision is not the decision that it was an aqueduct. The relevant decision is that this was expenditure which was only allowable in part. Expenditure on this structure was only allowable in part as a capital allowance. It was partly saved by List C, but not the whole of it. So the taxpayer has had part of the expenditure, the whole expenditure on the item, disallowed. That's the decision. It hasn't been quantified yet.
Yes,
that's the decision. The reasoning is because it was an aqueduct and it was only partly saved.
But that's
the reasoning.
Yes, but that doesn't get him home.
No,
because what he still needs to say, if you like, without using the word aqueduct, he still needs to say, your decision in principle was incorrect.
Yes.
Because you have allowed me only part of the expenditure, yes. And I want more expenditure. And if questioned at the hearing, he would have to say, well, why is it you say that? Where's the error of law? You are wrong in law in the decision you have given because you've characterised this structure as an aqueduct. So you get to the same place. I respectfully agree with the way your lordship puts it, because it's disallowing some of the expenditure in principle. But you can't get away from the fact that if the taxpayer wanted to succeed on this, it was going to have to tackle the question whether this was an aqueduct or not. And it is, in my submission, a completely wrong approach to say, well, let's look at what else is being argued by the people who have got permission to appeal in the case, because that doesn't engage with this issue.
Well, what they're doing is to say, because of the reasoning in relation to other assets, if one applied that reasoning to this asset, then the result would be different from the result the FTT arrived at. But I mean,
that's a challenge to the result below.
Yes, but is there
just dressing it up
in this in the authorities? Is there the statutory provisions that deal with what the FTT is actually doing when it's determining an appeal against a closure notice?
I'm sure there are, because of course the FTT has power without finally determining the appeals in figures. Of course, it very rarely happens that the FTT engages with the figures to give decisions on part or parts of the case. So I'm looking at tab 14. This is the FTT rules. Application for permission to appeal. It's internal pagination 139. The person seeking permission to appeal must make a written application to the tribunal for permission. An application must be sent or delivered no later than 56 days after the latest of the dates that the tribunal sends the person making the application the relevant decision notice. So that the relevant decision notice is what the FTT sent us. And
Sorry, where were we reading just then?
Rule 39 of the FTT
Yes.
rules. So
Which
the
paragraph?
the time provision at 39 sub 2.
ZA, the relevant.
Yes.
Oh, ZA.
The
I see.
relevant decision notice.
Yes, okay. So,
And then and that time runs from disposal of all issues in the proceedings or disposal, which must be the usual case, of a preliminary issue dealt with following a direction. And then at 39 sub 4, we see the power to extend time. Of course, the tribunal has full case management powers and can extend time on request with reasons. And
so sorry. No, go on.
I was just going to read on, unless the tribunal extends time, it mustn't admit the application.
Now, the relevant decision notice, that just, I mean, that's a pretty pro forma document, is it? I mean, I've seen them, but I can't remember exactly what
That's
it is.
the decision.
Sorry?
That will be the FTT decision.
Oh, is it?
And yes, and
It's
has,
not a separate
no,
document for it.
and it has it'll come with a covering letter, but it,
Yes,
it has
that's
a
what I was thinking.
standard rubric in the last paragraph saying this.
Well, that's what I was just looking at, though. So this is at paragraph 130 of the FTT decision here. So this is where we find the decision in
Yeah.
paragraph 130
Well-
on each of the items.
The decision is contained in what we get from the FTT.
Yeah.
Before we move off,
Well, but that's
Well, it's
what I'm.
Yes, but it's just summarising it.
Yeah.
I don't think that's
Okay.
separate. It's not like a
No, it's not like an order,
dispositive
but I consider the expenditure incurred on the respective items to be allowable or not as expenditure as follows, and then we see it either allowable in full or allowable in respect of this or that.
may I just pause before we go on to that at Rule 39, because
Yes.
I just wanted to draw attention to 39 sub 5. When applying for permission to appeal from the tribunal, the application must identify the decision. So one would typically say the decision is that contained in the decision of the tribunal dated so-and-so, under reference so-and-so.
Well, can I pause you there? Supposing there's one, you've got something like this one, this decision here, and paragraph 130 divided into quite a few paragraphs and sub-paragraphs. There's only one of those you take issue with,
Yes.
you want to appeal on.
Yes.
So when you identify the decision of the tribunal to which it relates, is that the whole decision or that particular paragraph?
I would say it's the particular paragraph.
Yes,
if you look
I
at the
would
way 5
imagine.
breaks down, so you identify the decision of
Exactly,
the tribunal
yes.
to which it relates, identify the alleged error in the decision, and state the result the party making the application is seeking.
Yes, so instead of being disallowed, we wanted it allowed in full.
You've allowed only part of my
Yes, yes.
expenditure. The error in the decision is that you treated the big concrete thing
As an aqueduct.
as an aqueduct.
Absolutely.
I contend that it ought not to be treated as an aqueduct. It is not prohibited, disqualified by List B, and there you
Even
are.
if decision meant the whole thing in 5A, by 5B and 5C, you would narrow it down to make clear which aspect of it you were
Yes.
complaining about.
Yes, you'd get to the same place.
And in this case, it's the subparagraph C at the top of page 168. Cut and cover reinforced concrete built on site. Costs of construction of conduit itself not allowable, but costs of excavation and subsequent recovery allowable in full. That's the decision.
I agree the
That's
decision
it.
could well.
I
I'm
think
not sure,
let's-
but I agree it would come out in B and C even if the
And
decision
you
is
get,
the
you
whole
get,
thing.
but you get there when
Because-
you start to identify the
Yes,
error.
it does.
anyway.
Because C says the result you want. So that,
Yes.
Because
Yes.
that final paragraph
Yes, okay.
might not have actually been put in.
yes, yes,
Could have just said, for the reasons above,
yes, quite.
yeah, someone is allowed and some
I see what
isn't,
you mean.
but you'd then have to identify where else. in the
Yes.
decision it
Yes.
And just by way of example of how I suggest it could and should have been done, look, if you would, at tab 9, which is my own application to the Upper Tribunal for permission to appeal its decision. Now, it's under the Upper Tribunal rules, not the FTT rules, but mutatis mutandis. So that's tab 9 at page, internal page 125. I'm in time, so I apply for permission. I seek an extension of time. I think Christmas was coming, so I wanted longer time to get before my documentation for the Court of Appeal. Then paragraph 3, the decision to which the application relates is that delivered on
I see.
this date, under that number.
The whole thing.
The errors in law are those identified in
I see.
9.2a.
And then somewhere you'll say what result you want.
I'm sure I do.
Yes, well, the rules require you to, so I'm sure you did. So that, but
I won't have overlooked
combining
that.
all that together, I see. Yes, I see. All right. So that's really the point there, isn't it?
I'm very grateful for
Well, anything
court's
else?
patience, unless I can help you.
No, well, thank you very much.
Terminates my session. Thank you.
Thank you, Mr. Peter.
Well, Lord, you will have seen from the various guiding arguments and having heard from a learned friend that there are issues here of importance as to the proper construction of the capital allowances rules, in particular where one is concerned with large-scale, renewable power projects. Some of those issues, as the court will perhaps have understood, are of potential importance to more than just this taxpayer. It has a wider either electricity industry or possibly even wider impact. And here I have particularly in mind this question about the alleged mutual exclusivity of 22.1a and 22.1b, and indeed the scope of List B. So those issues have a much wider impact than merely my clients. And in particular, although I hold no brief for the water industry, we ought to look at the water industry provisions so that we can see the full import of my learned friend's case. Other issues here are of perhaps wider importance, but only to those involved in renewable energy projects, so tunnel, aqueduct and pipeline. And then I'll turn in due course to the procedural question, which we recognise also has a potentially wider impact. Court will, I think, have understood from the various papers and from a learned friend that one gets tax relief for revenue expenditure in most, but not necessarily all circumstances, as a trading taxpayer. As a matter of principle, there is no relief for capital expenditure, and one does not get relief for either accounting or commercial depreciation. Instead, there is a provision made by Parliament for allowances. It goes back to the 1880s, but our modern system came in 1945 to encourage post-war reconstruction. And allowances are provided for typically on a writing down basis. Now, there are exceptions to that, but we're not concerned with the exceptions. And those writing down allowances will be set at a rate that provides for the effective economic write-off of the asset over a particular term of years. One doesn't need to do the maths out loud, but a writing down allowance at 25%, so a writing down of each year's balance, gives you full relief over about 12 years.
Right.
So if you set the rate higher than 25%, you write off faster. And if the rate is set lower, then you write off over a longer period. And at various points since 1945, those rates of writing down allowances have been set either with a view to matching what would otherwise be the commercial depreciation of an asset. And in those circumstances, what the law is doing is removing the disincentive to invest in capital assets in a world where you don't get tax relief for your capital expenditure. It's giving you allowances that match the rate of economic write-off. In some circumstances, Parliament will give you better than that, so you get a higher writing down allowance, so you write off faster than what would otherwise be the economic life of the asset, and that is designed to be an incentive. There are rare cases, and we're not concerned with them, where Parliament goes the other way and positively disincentivises certain types of capital expenditure by giving you a rate of writing off that is worse, indeed much worse, than economic depreciation. Now, coming towards our present ground, Parliament has at various points in time provided industrial buildings allowances, where the rates were either 4% or 6%, and they were broadly designed to be available for assets that would have a long life. Equally, Parliament has provided for writing down allowances at typically 25% for assets that were thought of as having a shorter life. But the legislation does not work by reference to the economic life of an asset. And the best and simplest example of that is the dry dock in Berkeley Curl, which was expected to last for between 80 and 100 years when it was built in the early 1960s. And yet the debate there was that asset plant, which would give writing down allowances, or was it an industrial type building when the allowances would have been lower? And the House of Lords determined on a 3-2 split that it was plant and it did qualify for the allowances. And that is an example of a wider trend in the 60s, the 70s and the 80s, whereby assets that might be thought of as having quite a long life were regarded as a matter of the common law as being plant. So when Mr. Dorrell explained to Parliament that there was recognition on the part of ministers, and one might infer on the part of Parliament, that that's a bit of a stretch, that there is a broad divide between long life assets and shorter life assets, that is true. And when the minister told Parliament that there was a desire to draw a line in the sand, that was what the government had in mind, and we can infer that's what Parliament must have had in mind. But drawing a line in the sand, as the minister made clear, was to be the line as the law then stood. It may or may not help, but think of the front line in Flanders, where the line moved backwards and forwards, with the no man's land moving with it. What Parliament said in 1994 is, we'll take the line as it currently is, and we will call that the line, with a view to ensuring that it didn't move one way or the other again. So that's what one gets from Parliament. Yes, there was an intention to draw a line. That line was to be determined as the law then stood, respecting what the courts had said about plant. But that, with the greatest respect to my learned friend, doesn't tell you anything necessarily about the answer to this appeal, given that we are ultimately concerned with the question of which side of the line are we on. So we've never been convinced of the propriety or the wisdom of looking at Hansard, but even if you do, you don't gain anything, we would say, of any help to you in answering these questions from what Mr. Dorrell had to say.
Well, the point of it is that otherwise one's left scratching one's head. This extraordinary miscellany of items, including cages in zoos, which appear in section 23. At least we know why there are cages in zoos, but not something similar, or something similar but not the same.
Yes. And your Lordship, I think, has this in mind, but it's worth restating that the way the statute worked when it came in 1994 was to disallow what would otherwise be plant. If you don't pass the common law tests,
Yes.
the debate ends.
Yes. Yes.
If you pass the common law tests, Parliament is saying, well, you still have to pass some statutory tests or statutory gateways, absent which you don't get allowances. And Parliament has done that in a 2 or 3 tiered way by dealing with buildings, then structures, assets and works, which I'll come to in a moment, and then saying, well, if you've fallen foul of either of those 2 sets of rules, there is a 3rd set of rules that will still preserve your entitlement to allowances, and that is List C. As my learned friend observed, much of List C reflects the case law of the courts, although not quite all of it. But for present purposes, what matters is that here, in this court, it is now common ground, indeed it was barely challenged below, that these assets are all plant as a matter of the common law. And I say it was barely challenged, we barely discussed that in the first tier, and it wasn't discussed in the upper tier, and here it is common ground. So these are all plant.
And they would fall within the general rule if they weren't taken out of the general rule.
The starting point, my lady, is yes. Before one comes to section 21, these are plant and they would be entitled to allowances. But that doesn't get me home because I have to chart a way through sections 21 to 23. And what the first tier did below was to take the assets as it understood them, having seen the photographs and the diagrams and the site visit and listened to Mr. Smith, accepted or decided that they were common law plant, and then tested each of the assets as it understood them against the statutory provisions. Now, in doing so, there was one logically prior decision it had to make, which is common to a lot of these cases, which is, do you look at an asset as an entirety, use the jargon in the cases, or do you look at it on a piecemeal basis? So theoretically, at least, it might have been possible to say, well, the Glendoe hydro scheme is a single asset. And you would then test that single asset against the statute. But that was not the position of the parties, and the tribunal finds that it should look at elements of the overall scheme, taking each of them singly, and adopt what is called in the case law the piecemeal approach. And whether to go entirety or to go piecemeal is, as a matter of law, been held to be a question of fact, and that decision was made by the first tier, and neither side has any cause to challenge it. And so that is why the first tier had to address each of the categories of assets, breaking down what was referred to as the water gathering assets as necessary, which is why you have now still, subject to this appeal, 5 broad categories of asset.
And the asset is the thing that you've got at the end of the day when you've stopped building or installing or constructing it.
My lady, yes. So you have them in mind, but there's the drilled and blasted underground conduit that's shotcrete lined. There's the cut and cover conduit. There's an uncovered rock and concrete lined channel section. There's the head race. And then the 5th category is the tail race and the other smaller tunnels, so the turbine outflow tunnel and the drainage and dewatering tunnel. And I'll come back in due course and say how we analyse each of those by reference to the statute, but that's why you have those assets grouped in the way they're grouped. That was the approach of the first tier, not said to be wrong in law, nor could it be said now, and they are all common law plant. So unless disqualified, my clients are entitled to capital allowances in respect of those assets. So that gives rise to, as we see it, putting the procedural issue to one side, which I'll come back to and deal with tomorrow, I suspect, 5 questions. Question 1 is, what's the proper application of section 22, subsection 1? That's the mutually exclusive question. Question 2 is, what's the meaning of tunnel and aqueduct in this context? Question 3, still faintly advanced by my learned friend, are these assets structures? Question 4, what's the scope of list C item 22? And then question 5, what about pipeline in C25? So as regards the first of those questions, section 22(1, we know, we think, that Parliament wanted to express in statutory terms that dividing line that it wished to establish more clearly between plant and machinery on the one hand and buildings, structures, assets and land on the other. And that exercise required the identification and then the application of 3 rules. The first rule is you don't get plant and machinery allowances for expenditure on buildings. And this case doesn't now turn on that, but buildings here has an extended meaning, so as to include the things that are listed in list A. Second rule is that you don't qualify for allowances for expenditure on certain structures or assets. That's list B. And then the third rule is you don't qualify for expenditure on works where those works involve the alteration of land. But the scope of those rules...
So you say that the third rule is you don't qualify
for allowances on works where those works involve the alteration of land.
That's the odd thing about that third rule, is that then you're not looking at the end result as you are with the plants or the structures or the buildings. You seem to be looking at the process, which is why it doesn't seem to be the same kind of thing.
You are, my lady is right, you are asking a slightly and subtly different question. Here, I do have observations to make about how this legislation is designed to work. So it would help if you had the first bundle of authorities, it's tab 3. So this is the legislation as it stood in 2006. And bundle page 32 has section 21, which is the exclusion for buildings. And I say buildings here has a particular meaning because subsection 3 tells us that it at least includes certain items that are in list A. So whatever the draftsman thought the meaning of building might otherwise be, here there's a special exemplified and exemplified meaning of building. But subsection 4 is that subject to section 23, so list C. And then over 2 pages, we get to page 34. In fact, we should have paused at, I should have got back one further page. Could we just go back to page 31 for a moment? This is the chapter heading. Chapter 3, qualifying expenditure, buildings, structures and land. And one could annotate under that, buildings is section 21, structures is section 22, and land is section 24. So then we've seen buildings on page 32, and then we get to page 34, and the heading here is structures, assets and works. And then subsection 1.
What's the present learning on marginal notes? It's 20. So what you've called the heading. Are we? I mean, the old rule was you could look at the heading you showed us on page 31 because that was part of the statute. But you couldn't look at what you call the heading for 22. But are we now allowed to look at the heading as an aid to construction?
The last word that I recall is that it's something you're entitled to look at, and then the weight you give it is a matter of personal choice.
Right. Okay.
And I will check this evening whether I've misremembered.
Because it used to be that the headings to each section, I think, were added after the bill had been enacted.
Yes.
Whereas the group sections headings were not. But anyway, all right. But the point is made, isn't it, in section 22, because that actually goes beyond talking about structures to talking about assets.
What I want to do, and I quite accept that I start with the headings, but what I want to do is to show you why the headings make sense.
Yes, all right.
So you have the point about structures, assets and works in the heading. Then 22.1, so the opening words is the barring rule, you can't qualify for expenditure on. And then A, the provision of a structure or other asset, but it has to be in list B. Now, we have long wondered about what's the significance of the reference to other asset. And the best explanation I can offer is if you look in B4, the reference there to dam, reservoir or barrage, it includes sluices, gates, generators and other equipment. So that's an example of something that would be an asset that's in list B that might not be a structure. In fact, the generator is not. Now, we don't see any other reference in items B1 to 6 to items that would be assets. So we think that the reference to asset is to those items in B4.
Because those are assets but might not be structures.
My lady, yes. The best example there is the generator. But going back to 22.1a, it's not all structures necessarily, it's structures that appear in list B. And then in B, the draftsman is dealing with, I say, a separate category, works, where those works involve the alteration of land. I'll come back to the significance of that word or in a moment. Just reading on down B, ignore 7 for a moment. The draftsman lists in 1 to 6 particular items, so they could have been written as one continuous list, or they might each have been numbered. I haven't actually counted them, but let's assume there are 25. They could have been numbered 1 to 25. Or there could have been 2 categories. Everything in 1 to 6 would have been in one list, and 7 would have been everything else. But the draftsman doesn't do that. they are grouped. And that grouping, we must assume, was deliberate. And I'm going to say they are grouped by broad theme. So one can imagine looking at an ordnance survey map and looking at item 1, and you will find tunnel, bridge, viaduct, aqueduct, embankment or cutting. Now, I do not suggest that that was done with that in mind, but they all carry with them that flavour of roads, railways, canals. Then 2, clearly again, we would say a transport theme, so way, hard-standing, pavement, road, railway, tramway, etc. Just pausing there, in 2, the best categorisation we can see is that those are the very things, the road, the railway, the tramway, those are the things that go through or over the things in item 1. So item 2 is broadly the transport routes with associated assets, and item 1 is how those transport routes make their way across the country. 3 is clearly water related, navigable waters. 4 is about holding back or constraining water. 5 is about the interface between commercial operations and the sea, or at least water. And one gets that from or any other structure in or at which vessels may be kept, or merchandise or passengers may be shipped or unshipped. All shipping related. And then 6, it's about holding the water back or constraining or controlling water. And I'll come to 7 in a moment. So they are undoubtedly organised deliberately in separate lists. I submit again with broad themes. And so when Parliament uses a particular term, tunnel or aqueduct, one must seek to understand why that term was chosen, what is it intended to convey, but also why does it appear where it does. And that is most acutely true of aqueduct. If my learned friend is right, one is entitled to ask, why does it appear in list 1? Is it not subsumed by either 3 or possibly 4 or possibly 6? And even if it's not subsumed by or covered by any of the items there, why doesn't it appear with them?
Sorry, which aqueduct?
Aqueduct. My learned friend is right that it is any conduit that holds or delivers water. Does that not trespass upon items that are in 3, 4 or 6? Or even if it doesn't, why doesn't it appear with items 3, 4 or 6? Now, I'll come back and develop this in a little while when we get to tunnel and aqueduct, but one needs to respect both the word that Parliament has chosen, but where Parliament has put it. And then just continuing with my analysis of B, 7 is any other structure with the saving that certain structures are protected, either if they're in use for the gas industry, which is B, or the telecoms industry, which is C, or they're in use for other industries that are within A. Now the court wasn't shown this, but if we just turn quickly to tab 4, page 64, this is what tells us what counts as an industrial structure. And you'll find page 64, section 271. And this gives allowances if you've got an asset B(1) in use for the purpose of a qualifying trade. And then section 274 at page 67 provides that a qualifying trade is a trade of a kind described in Table A or various undertakings in Table B. And then Table B, page 68, item 1 is electricity. So you have to be an undertaking for the generation, transformation, conversion, transmission or distribution of electrical energy. And so if we're in B7, this is why we are saved from the effect of B7.
I see.
Because we are an electricity undertaking. But can I invite you to note the second type of undertaking in that table is water.
Yes.
An undertaking for the supply of water for public consumption. And item 4 is sewerage. So very broadly, what this is doing is saying that if you are in the electricity industry or the water industry or the sewerage industry, or indeed the gas industry, because that's specifically listed in 7b, then your other structures are entitled to allowances because their position is preserved.
Because their
Position is preserved. But as Milady observed to my own friend, the broader meaning one gives to 1 to 6, the narrower the scope of 7, and the narrower the scope of the saving afforded to the gas industry, the electricity industry, the water industry. I'm not here to bat for the water industry, but if my learned friend is right about the meaning of aqueduct, how broad it is, and there are a lot of assets in the water industry that will be caught by B1 and will not benefit from the saving in B7A, and that's an inevitable consequence of the breadth of what is said to be B1, cutting down the ambit of B7, and therefore reducing the impact of Parliament's clear intention, which was to preserve allowances for structures in the water industry, the gas industry, and the electricity industry.
Well, and many other industries, because Table A, which we haven't looked at, is itself very wide.
My lord, yes.
It's not. You are not the saving in item 7 is not.
It's not.
7A is not limited to those in electricity, water, sewerage, and so on.
My lord, it is not.
It's manufacturing, processing, storage, agricultural,
All sorts of
mineral extraction. It's a very broad
My lord, it is.
category.
So, look,
Provided that it's not a structure within
Provided
1
it's not
to
within
6.
1 to 6. Yes.
yes. And so, if my learned friend is right, in particular about aqueduct, and the very broad meaning he would seek to give it in this context,
I see. You're saying, well,
that will cause considerable concern to those in the water and the sewerage industry.
well, I don't think you can just tell us that.
No, well, I'm not.
I mean, I
making-
don't know. So far as I know, they well accept that a lot of their works are aqueducts.
I don't
I mean,
want to say I'm here batting for the water.
No, you did say that. So I don't think we can take any judicial notice of whether or not it would give concern to them unless that's illustrated by a case that's been.
But your lordship, I think, has the analytical point I'm making.
Yes, I
The
follow.
breadth of one cuts down the scope of the other.
Yes.
Now, what we say, and I'll park B1 for now and come back to it under my second question. But what we say in relation to the structure of Section 22, and we say with respect this is the step that my learned friend misses out, is that the draftsman has in mind in 22.1 that you are an asset that is a structure or other asset, and in those circumstances you will test the entitlement against List B, or you are not a structure or other asset, but you are works, I would say merely works, and then you test those works against 22.1. So it's not a case where an item of expenditure has to pass both tests. Instead, what the draftsman here has in mind is that you identify if you're an apple or an orange, and you then apply the apple rules if you're an apple, that's 22.1a and List B, or if you're an orange, then you test against the orange rules, which is Section 22.1b.
I don't really follow that. You'll have to just unpack that a bit for me.
The draftsman in 22.1 knows that he needs to provide a rule that deals with structures and assets on the one hand and works on the other. And if you're in the structures and assets category, then you are tested against 22.1a, which takes you to List B.
Right.
But if you're not a structure or other asset,
I see.
then you are works.
But the difficulty with that is the difficulty we were alluding to earlier. You say if you're not a structure, the difficulty is that, as we said, A and B are not, it's not an apple or an orange, it's an apple and picking an orange or picking a piece of fruit. Because you're not, in the one you're looking at what you end up with, and in the other you're looking at what you actually are spending the money on doing. And the trouble is that a lot of the money you spend on doing ends up giving you a structure or an asset, and it's difficult to know whether then B is a subset.
It's a very odd,
It
isn't
is.
it? Because it, what,
If it said the provision of the asset
Yes.
or the alteration of land, or an alteration of land, creating an alteration of land, then it would be clearer what I think you're going to say, which is that if you end up with a structure or an asset, that's in A, and works involving the alteration of land must mean works that don't end up with a structure.
Well,
or an asset.
that is where
Yes,
I
I
get
see.
to.
Yeah. But
yes,
it-
A is directed to, you say, to structures or the other asset in the list.
Yes.
And B doesn't mean works involving the alteration of the land, even if they end up in the provision of a structure or an asset, but other things.
Yes. And I say that in effect for the reasons that I put to the Upper Tribunal, which were accepted. But I say Parliament determined to deal with those things separately. And one can see from 22 subsection 3 that Parliament is determined to keep these different concepts separate. So little a tells us a structure is a fixed structure of any kind other than a building. So you're told structures are different to buildings, 22.3a. And here we're told you take the Interpretation Act meaning of land, but it doesn't include buildings or structures. So Parliament is drawing a distinction between structures, buildings and land. And this section, that definition of land only applies in this section. There's a different definition of land elsewhere.
But it doesn't exclude other assets other than structures.
My Lord, it doesn't, no. And the only explanation I can give to that is that one understands from the reading of 22.1a and item 4 in B that the other assets reference is to deal with those things that are in B4, and they are to be treated as falling in the structures camp.
But you say that land means the earth rather than things built on the earth, which become the land in ordinary
Yes.
legal terms. So that if subsection 3b hadn't been there, someone might have argued, well, land always includes buildings, so any works involving the alteration of a building should be a work involving the alteration of land, but that's ruled out by 3b.
My lady, yes, and that's why section 22 has to have its own particular meaning of land.
Yeah.
So I rely on the structural point and the, in a sense, the ordering point. I rely on the meaning of land. And I rely on this point, that if Maloney Friend is right, then for our part, we don't think you can construct any of the items in list B without there being works involving the alteration of land. The test is, are there works, and do they involve the alteration of land? And Maloney Friend, with great respect, can't identify a rational divide between those two, save that he's forced to suggest that, well, maybe it's a reference to things that are incidental or ancillary to. But with the respect, that's just not in the legislation. And he's driven to that by wanting them both to cover the same or a very similar footprint, but then explain how they can operate separately. Whereas for our part, we say they were designed to deal with different things. Because if I'm wrong about this, then B7, little a to c, let's focus on little a, I necessarily, if I'm in the manufacturing or the electricity or the water industries, I don't get the benefit of the saving of 7 little a, because whatever my structure might be, it either will or is highly likely to fall foul of any works involving the alteration of land. Indeed, if my learned friend is right, why in a sense did Parliament need little a? Could have just said no allowances for expenditure on works involving the alteration of land, and that would have caught B1 to 6.
What about renovation, which was a point I put to Mr. Brown?
It's not certain that that would be capital expenditure. There is a divide between repair and improvement on the case law. So renovation could be either. But if I take the force of your lordship's point, let's assume it's capital expenditure. Relief is available for the construction or the acquisition of the asset, but unless you can say that there is an asset that qualifies as plant, which is the product of your construction activities under the guise of renovation, then you're not certain to get allowances at all. And the reason I say that is Parliament was alive to this in the case of buildings. It's not a provision this case turns on at all. If you turn on in the one, still in the same tab, to section 25 at page 41, Parliament has dealt with the circumstance in which you incur expenditure on an existing building that's incidental to the installation of plant or machinery. Now, that's not quite on all fours with your lordship's question, but it is an example of Parliament recognising that there might be ancillary or incidental expenditure that wouldn't otherwise qualify for allowances, and then Section 25 tells that in the case of buildings it does.
But if I have a container terminal in which I want to put in a whole lot of more up-to-date equipment to move the containers, very substantial capital expenditure, but it doesn't actually involve having to make any changes to the hard standing to which it's fixed. That's not going to involve the alteration of land, but it would fall fairly and squarely within List B, wouldn't it?
Well, Lord, if it's the very big cranes or the transporters that move the shipping containers,
Yeah, something like that.
they're machinery in their own right, and they're not in B at all.
They're not in B at all, or they're excluded because of List C.
Well, they wouldn't be in B 1 to 6. They could be within B7, but then they'd be saved by 7A.
They're not structures. One could sort of multiply examples, but I don't find it difficult to hit upon something that would seem to be a structure of the kind in 1 to 6, where we're not talking about construction and we're not talking about alteration of land.
Well, if the result of the expenditure is an item of plant that passes the common law test, then you would test that expenditure against B1 to 6. Or if it's not in B1 to 6, you'd test it against B7.
But if there is such a beast, that rather undermines your point that everything in A involves alteration of land, and therefore it would be odious to have B as a separate category.
Well, can I duck that question for now? Just think the logic through possibly overnight, and if need be, I'll come back to you on that. At the moment, I'm struggling, and the fault of that is mine, just to see how that further expenditure would fit into the Capital Allowances Code at all. Perhaps if I can come back to your logic on that.
Of course. Whilst I've taken you off your track, can I just ask something else that's troubling as well? Going back to the scope of item 7 and the correlation between A, B, and C, and you've shown us that A covers what's in 271 and 274. 271 for the purposes of qualifying trade, and then the 274, the qualifying trades are Table A, lots of things, and then Table B, particular undertakings, gas, sewage, water, and so on. And Table A, for example, includes anybody who is involved in processing or in mineral extraction, which is defined to include geothermic products. So if we look at 7B, the structures which are in use for extraction, production, processing or distribution of gas will all, or almost all, very likely for a gas undertaking whose trade it is, fall within A.
So why is B there?
Well, and one might say the same with C. And so when we get to the argument that it's very important that the gas industry and the telecommunications industry should have their preservations preserved, as it were, by B and C, it's slightly odd that they're not simply put into Table A and Table B under 274. And it strikes me that one explanation may be that in relation to these particular categories of activity, gas and telecommunications, they're there to cover expenditure by entities for whom that is not part of their trade. So it wouldn't come within A because it's not part of their trade. But if I have a particular business and I expend money on putting on my land a mobile phone mast, quite a common sort of thing, that's something that might come within C, but wouldn't come within A, which is only going to cover those for whom it's part of their business.
In answer to that last observation, well, the answer is no, because C requires that the trade consist in the provision of. So it can't be anything else. It's people whose business is and is only.
Yes, I see.
But in answer to your Lordship's earlier question, why are B and C there? It is a quirk of the drafting. When these provisions were first introduced, there was in effect a cross-reference to what is now sections 271 and 274, but for reasons that no one can identify, there'd always been a reference to the electricity industry and water and sewerage and all the rest of them, and there'd never been a reference to gas. That's true all the way back right to 1945. And when these provisions were introduced, that was dealt with, and so B and C came in 1994. And if we go back to tab 1, page 4, this is the section 117 introduced what was then the schedule AA1, and here you're in paragraph 2, which just go back a page, is structures, assets and works. So this is the forerunner of section 22. And then the notes on page 4, note 2, is for the purposes of G in the table at the top of page 4. So G bars any structure not within any other item in this column. And then note 2 cuts down the scope of G where you have an item that is a structure that is or is to be an industrial building or structure as defined in, it was then section 18 of the Act. And that's the forerunner of section 274. And that section, as it applies to the purposes of this note, shall have effect, as if after electricity there were inserted gas.
Sorry, where are you reading?
Note 2, little
yes.
a, in the middle of page 4. So the way it was done in 1994 was to tack gas onto electricity. And then there's a definition in 2 little c inserted of a gas undertaking. And then little b in 2 made provision for telecommunications. Now, why that wasn't done by way of an amendment to what was section 18 and is now section 274, I'm afraid no idea. There's no legislative clue, there's no explanation in Hansard, it was just the technique that was adopted at the time. But from 1994 onwards, even though it's been done in a seems a slightly clumsy way, Parliament is to be taken to have intended that what is now item B7 protects structures in use for, amongst others, gas, telecommunications, and here electricity.
But were they, looking at table 2 on page 3, were the unaffected expenditures only relevant to the structures and assets which they appeared next neighbouring to? So if we look at any tunnel, bridge, viaduct, aqueduct, embankment or cutting, and then the expenditure which is unaffected is the installation. But was that read as it's only installation of tunnels, bridges, viaducts, aqueducts, embankments or cutting which is unaffected because of that note?
My lady, no, there are two oddities about this.
Right.
In the Queen's printer's copy, there are no table lines.
Right.
But then the better answer to your ladyship's question is if we go back to paragraph 2.2, in the middle of the page, it tells us that this barring applies to any structure or other asset that falls within column 1.
Right.
And then 2 sub 3
Right.
says subparagraph 1 does not affect the question of whether any expenditure falling within column 2 of table 2.
So any of the items in column 2 can apply to any of the items in column 1.
My lady, yes. Although the other wrinkle is, if one goes back to page 2, the forerunner of section 21 did the same thing. It had a barring list in the left-hand column, table 1, and a saving list in the right-hand column. But at that stage, the saving lists in each of the second columns only saved from the items in each of the first columns.
This is the equivalent of list A.
Yes. And when the legislation was rewritten, that was altered. It was a deliberate recognised change.
Yeah, I mean, how far is this valuable in trying to construe the act we have to construe?
For my part, I want to ensure the court is not left with anything that's troubling the court.
No, I understand
It's
as
my
to how
fault.
we get.
I sent you off down this road.
But I mean,
But for
you
my
know,
part,
each of these acts, none of them are necessarily that easy. They all have their wrinkles, shall we put it that way. But the wrinkles may be different.
And
For
the
your only
subsequent legislation may or may not have been intended to
Well,
iron out that wrinkle.
you exactly.
the court is only concerned with the legislation behind tab 3.
Yeah.
There are an awful lot of wrinkles to this legislation, which in retrospect has actually been rather badly drafted. But
I mean, can I just take you back? I'm sure you're coming to this, but what my lady raised, which is this difference between the language of A and B, whereas A is talking about the provision of a structure, which mirrors, in a way, the opening words of 1, the provision of plant and machinery, does not include the provision of a structure or other asset. So those structures or other assets are not plant or machinery, where otherwise they would be or might be. But then we get this very different phrase, does not include expenditure on any works involving the alteration of land. And I'm just having, in the light of what you're saying, I'm just not quite grasping what it is aimed at the moment. But as I say, that's something you may be coming to.
for our part, we see the divide between expenditure on the construction or acquisition of a structure or other asset in this,
Which is dealt with in A.
which is in A.
So if it's a structure or another asset in B, so that's a bit sort of on its own. It's really structures you're looking at. Is it?
For our part, if I'm right that the asset is referenced to those items in B4, we can ignore them for present purposes. We're concerned with structures.
But you're saying basically the provision of structures is dealt with exhaustively in list B.
In list B, yes. Now, the other, which I was attempting, perhaps rather simplistically, to describe as an apple rule for apples, and then little b is concerned with expenditure on works. It may or may not help to interpose, but civil engineering works, in that sense, that is not expenditure on the provision of a structure, but where those works involve the alteration of land.
So, I mean, does it mean that the works are the plant and machinery?
This is a barring rule.
Yes, no, I appreciate that. But what would otherwise
What would otherwise be?
So the works would otherwise be plant or machinery. Is that it?
Or is the alteration of the land?
Yes.
No, it's.
Well, I don't know. You're right.
It's a bar to
Yeah.
expenditure.
But what is envisaged by B? What can you give us some examples of what's in B?
One example that has occurred to us is if you own a shooting range, you may, at the end of the far end of the rifle range, build a bank to take spent bullets.
Yes.
And that would be works, I would interpose civil engineering works, that at least may, I won't say will, but may have a plant-like function. They may be common law plant. That would not be a structure, certainly not one that's within list B, but you would have incurred expenditure on works that did involve the alteration of the land, because you push the land up to form
Yeah,
a
that's
barrier.
right.
And in those circumstances, you wouldn't be caught by 22(1)(a), but you would be caught by 22(1)(b), unless you can find yourself saved by some provision in C.
Is there anything in C which would sort of naturally fit with what's in B?
It's not one of the listed items, it's not one of the ones that was the subject of
No, what I mean was nothing in list C would otherwise fall within B. that you
well,
could point
the
to.
only contender is C22.
Yes. That's what the puzzle is, that it envisages works not being a structure or other asset, but still being plant or machinery, even though they really only comprise the alteration of land. So you have to, when you're trying to think of an example, you have to think of, well, what could be plant or what could be plant which arises from the alteration of land but doesn't involve the provision of a structure or other asset.
Well, there have been cases about golf courses.
Well, that was the one I thought of.
So if one
Yeah.
creates an elevated tee or an elevated green,
Or a sand pit.
or a series of interlinked bunkers that it's almost impossible to get out of, that's something that may be plant. It's not a structure or other asset, certainly within B, but it would be works involving the alteration of land.
It's sort of, I mean, it's a bit of a sledgehammer to crack a nut, this, isn't it? I mean, they've included a sort of paragraph B covering virtually nothing so far.
Or virtually everything, if the learned friend is.
Well,
even sorry, because his definition, which my lady referred to, was this morning, I think, land is being altered so as to function as plant.
yeah.
It's actually not very far, perhaps, from what you're suggesting.
But my learned friend has to identify a scope for 22(1)(b) that doesn't render 22(1)(a) unnecessary, and also doesn't remove the effect of the exclusions to E7.
But the difficulty then is what's left of 22(1)(b), given item 22 in list C, because if your bank to take the bullets at the shooting range is plant, so the work involved, even though it's not a structure, but it's still plant, the work involving the work done to create it is a work involving the alteration of land. But then I think you say, or the FTT said, it would be an alteration of land for the purpose only of installing that bullet receiving bank.
Milady, yes, and there is clearly intended to be some relationship between the width of 22.1b and the width of C22. But they're not necessarily coterminous. It would be rather odd if they were. Of course, my learned friend here says that 22.1b has a very wide meaning, and you shouldn't be concerned about that because appropriate cases can be saved by C22. And yet when we get to C22, he tells us we're barred by 22.1b and we're not saved by C22.
I'm finding this really puzzling, but can I just put another angle to you? If one looks again at section 22.1, what it says is expenditure on the provision of plant or machinery does not include expenditure on any works involving the alteration of land. So it's not necessarily there looking at the end product, is it? It's looking at, you're saying, I have spent money on altering land.
Well, my lord, no, the test is, have you spent money on works?
That's true.
Where those works...
Any works involving the alteration of land. Well, but the works must, well, you mean involve doesn't necessarily mean comprise, but it may be a bit more than include, or maybe it's the same as include, I don't know.
The barrier is but expenditure on works, but only where those works satisfy one further criterion.
Namely?
Which is that those works have to involve the alteration of land.
But they don't themselves have to be plant or machinery, do they, the works?
Well, they do, because this rule is not necessary if they haven't passed the common law test.
Well, it's saying expenditure on the provision of plant and machinery does not include expenditure on any work. So if the provision of plant and machinery includes works involving the alteration of land, then that expenditure is not allowed unless it's prior to the installation under C22.
I quite accept that the language is expressed differently as between A and B.
Yes.
And they are aiming at, or they are providing for subtly different tests. But this rule is designed to operate in circumstances where you have an item that has passed the common law test.
Yes.
And you want to take the allowances away, or what would otherwise be the allowances, in circumstances where you're not within little a.
Well, you say take them away, but it may be reduced. May reduce the allowable expenditure.
Well, that comes back to the point I made at the outset, which is, are you looking at the entirety of the asset or on a piecemeal basis? And if on a piecemeal basis, on which piecemeal basis?
I mean, well, it almost suggests that's why I'm focusing on this repetition of the word expenditure, because it almost seems to be suggesting that you're looking at an element of the provision of the plant or the machine. But this may be a totally heretical view. I do understand that, and not what anybody has ever envisaged as being the purpose of it. But I'm just as puzzling about this, the choice of language here, and indeed puzzling about why B is there at all, really. May I say that I think there's an awful lot in list B which would not be covered by B. I mean, I don't myself think that, for example, a bridge is works involving the alteration of land in the sort of sense that you have described it. Or indeed, I'm not sure it is in the way Mr. Brennan has described it either, because the bridge is there. I mean, but the land is altered at each end of the bridge. I mean, I do see that there's a different sort of function for A.
I would, in answer to your lordship, our submission would be that necessarily you have to have works that alter land.
Yeah, I follow that.
To build a bridge.
I absolutely accept that.
And indeed,
in almost all cases.
But the alteration of the land is a permanent feature of a permanent outcome of the works. So it's not just digging a hole, putting something in and covering it up again, because you haven't, well, in a way you've altered the land, even though it looks the same.
The cut and cover example we'll come to, the land is altered. Because before it doesn't have this, I'll try and use a neutral, it doesn't have this concrete tube through it, and afterwards it does.
But is your submission essentially that B is focusing on the end result, and the end result it's focusing on is the altered land as such? So you've got something which is, we would describe as land in its broader sense of, let's say, earthworks. So you've got your bank at the back of a rifle range, and it might, would it also cover, can you have gardens and cosmetic landscaping which could be planted as part of, say, a caravan site in the same way as a swimming pool could be?
My lord, yes. Or there are a series of cases about decorative assets in pubs and restaurants. Now, principally they're about things internal, but in principle you could landscape a garden in a way that would be designed to add to the ambience and the look and feel of the venue, and that may well be planned. And in those circumstances you would then need this rule in a world where Parliament has been very careful in 22.3b to give land its own particular meaning. So in land in 22.1b is designed to mean something separate from both buildings and structures.
Sorry, land in 22.1b.
22.1b.
Yes, you've got to alter. I mean, very broadly speaking, you've got to alter what everyone would think of as land.
You've got to alter the earth.
You've got to alter the earth, exactly, yes.
And not just in order to, well, I could understand it. If item 22 said alteration of land for the purpose only of installing a structure or asset, then that would get past your putting in the concrete foundation of the telephone mast, but it doesn't. It says purpose only of installing plant or machinery, which then creates this conundrum, which is that if all you've got at the end of the day is the alteration of land, and that is treated as the plant or machinery, what possible works can there be that don't install it? Doesn't make sense then.
Well,
Anyway.
Mr. Speaker, I see it's 4:15 now. I mean, we're happy to sit a bit longer, I think. I'll ask if it's helpful or you need to rise. I mean, it's up to you, really. I mean, if
Well, obviously I wouldn't finish tonight on any basis. This might be a convenient moment, right, and I will undertake to think more carefully about my Lord's renovation question and then come back with that tomorrow.
I mean, we're having difficulty, all of us, I think you can see, with B, actually, quite what its sort of intended scope is. So I think that's helpful. But, I mean, in a sense, perhaps you have said what you wanted to say about 22.1, have you? Your first question. I mean, we've rather detained you with our further concerns.
So there are two things I need to do. I need to show you what the Upper Tribunal said.
Oh, yes,
because
of course.
this is an appeal from their
Yes,
view,
indeed,
so
absolutely.
you need to see
Yes.
how they put it, not just how I put it.
Yes, yes.
And I've got one or two observations about the Commissioner's case, but that would only take me, I should think, 15 minutes tomorrow morning,
All right.
and then we'd move on.
All right, very good. Well, thank you very much indeed. We'll sit again at 10:30. Thank you both very much for doing your best to finish today, but I'm afraid despite your best endeavours, we have not. 10:30 tomorrow.
I don't know if your lordship is interested. You mentioned the weak character of a noscitur a socis.
I did, yes.
The case which Ms. Nathan has ferreted out is Customs and Excise Commissioners against Wellington Private Hospital, and it's reported 1997. Simon's tax case is 445.
Well, it might be helpful to. I think there may well have been authorities before then, but is that which?
That's in the Court of Appeal.
Court of Appeal, you say?
Lord Justice Miller.
Yes. Well, that sounds. Yes, it's Customs and Excise and Wellington
Commissioners
Hospital.
against Wellington Private Hospital Limited. Reference 1997. Simon's tax cases 445.
Well, thank you very much.
Shall we bring the copies?
Well, I think it might be helpful actually. Yes, I wouldn't mind. Good. Very well. Thank you all very much.
All right.